Well, thanks for coming. My name is Mitchell, and I've been here a number of times. I'm from the University of South Carolina, and I usually talk about legally oriented issues because although my area is actually teacher train at the university, I'm really involved in special education, primarily mildly handicapped youngsters. My real interest has always been in law. And someone in our session the other day said, "Boy, you're kind of a nerd about this stuff, aren't you?" And I proudly said, "Yes, I am. I'm proudly a nerd, and I like it, talking about it probably more than most people like listening about it. So, but you'll just have to put up with me for a little while. But today I have something real important to talk about, and that's the decision in Endrew F v. Douglas County School District. And that, of course, is the latest Supreme Court decision in special education. And people have different opinions about it. You know, some people say it's not that big a deal. Some people say it's a pretty big deal. I lean toward the pretty big deal side. And I think there's some really important implications for special ed directors, for teachers, for attorneys who work with school districts. It might really change their lives. But anyway, that's what we're going to do today. Is we're going to talk about Endrew F v. Douglas County School District. And I'm going to start out actually by talking a little more generally about free appropriate public education, because that's what this decision was about. But first off, I am from South Carolina. But I'm actually originally from the Midwest. I'm from Minnesota. So you'll not hear me talking about cutting checks or pushing buggies around grocery stores, or I won't say might, could have, or y'all very often. And I don't like grits. So I'm really not a Southerner. I'm more of a Midwesterner still, so I really enjoy it when I come back to Indiana. This I think is a game changer. This new decision from the Supreme Court, and the reason I say it's a game changer is because what our charge as special administrators, as special ed teachers, is really to develop an educational program that confers meaningful educational benefit for the youngsters with whom we work or we teach. And free appropriate public education, that actually is not a new term. I mean, that was the term used in 1975 when Congress originally passed the Education for All Handicapped Children Act, saying that's essentially what we do. We develop IEPs, we develop special education programs that confer a free appropriate public education. Well, one of the problems was the federal definition of free appropriate public education was not exactly a model of clarity. It said that special education and related services must be provided at public expense. That is, we don't charge parents for anything that we have in the IEP, that it meets the standards of the state educational agency. And the reason Congress put that there is because actually education really isn't a federal prerogative. Only what's in the Constitution is the prerogative of the federal government. Education isn't mentioned in the Constitution because the Founding Fathers thought that it was actually such an important issue that it needed to be handled locally. So there's really nothing in the Constitution. Well, the way Congress gets around that in the idea in No Child Left Behind and Every Student Succeeds Act is they essentially provide money to states. And what also they do is, now a lot of people say this is a civil rights law. It's really not. It's what we call a program law. It's a law that provides funding to the states. And in 1975, as you probably all know, there was a great problem in the states had really uneven programming or laws or no laws regarding educating youngsters with disabilities in public schools, so the federal government thought there needs to be a federal standard, and so they passed this law. And essentially, the hook on this law was states, you have to pass your own law, and if you do, we will give you up to 40% of your costs in educating youngsters with disabilities. And so every state but one, but New Mexico, passed their own law. We have Article 7 here in Indiana that essentially mirrors the Individuals with Disabilities Education Act. What Congress did is said your laws that you pass have to mirror our law, the federal law. You can offer more if you want, but you can't offer less. So, for example, what this means, meet the standards of the SEA. If this state educational agency has additional standards above what the federal government says you have to offer in the IDEA, that just means you have to follow that. For instance, I'm sure you all know, when is transition required in Indiana? At what age? 14. And the federal government says 16. So we have to, in Indiana, have to follow the state law, Article 7, which says 14. So that's why they put that there. Now, states couldn't offer less. Indiana couldn't say, for example, we're not going to require youngsters with emotional behavioral disorders to be educated in Indiana. They couldn't do that because they're offering less. In order to get that money, they had to do at least what the federal government told them to. And the old saying is, if you take the king's money, you abide by the king's terms. And that's essentially what this is. That's why that part is there. Some states, like California and New York, have a lot of additional requirements beyond what in Indiana and South Carolina have the transition requirements. So if you're in California, you have to do what they say, what their law says. So that's what that means. Includes preschool, elementary, or secondary education, and fourth, are provided in conformity with the IEP. And that's an important part because it essentially says that individual education program, that IEP that we create, that constitutes a F.A.P.E. That is a free, appropriate public education for any given child. However, because that is not a really complete description, almost immediately in 75 on the passage of what was then the Education for All Handicapped Children Act, and is now the IDEA, we started to see litigation in the area in special education. Now, litigation in special education over the years has amounted to the vast majority of litigation education as a whole. Probably, maybe 10, in Indiana, probably 10% of our population is in special education. About, if we take all the litigation in education, about 90% of with all secondary education, everything, 90% of the litigation comes out of special ed. So even though we're only 10% of the population, we account for about 90% of the litigation. That's because IDEA is really written in a way that if we can't collaborate and come up with a program at the IEP meeting, the parent can go to due process, they can file a state complaint, things like that. But of all that litigation that we have in special ed, between 85 and 90% is about F.A.P.E. It's about free, appropriate public education. That's why this is such a big deal. This was the second case heard by the Supreme Court on F.A.P.E. What exactly is a free, appropriate public education? Now, this is Amy Rowley, and you probably all have heard of Board of Education v. Rowley, 1982. It was the first special ed case ever heard by the Supreme Court, and it involved this young girl who was deaf, profoundly deaf. Her parents were profoundly deaf. They lived in Peekskill, New York, upstate New York, and she was beginning kindergarten a few years after the then Education for All Handicapped Children Act became law, and her parents were very excited. Her dad was profoundly deaf and taught at, I think it was Fanning Hall, which was a school in upstate New York for deaf children. And her mother was actually a teacher at one time at Gallaudet University in Washington, D.C. And they were very excited about this new law that talked about least restrictive environment and free, appropriate public education. So they decided, they had thought Amy was going to go to the school for the deaf, Fanning Hall, But what they decided is we want to send Amy to a regular school. The school was called Furnace Woods Elementary School in upstate New York. And so before she started kindergarten, the parents called the school district and then talked to the principal of Furnace Woods about, we want to enroll Amy. The principal was very excited about that, having this a youngster with disabilities and this new law, having Amy in his school. So they said, well, what can we do to make this the best possible education we can for Amy? And the parents talked about, well, what they asked is, well, could we meet? They met. They didn't do an IEP, but they met. And the parents requested that they have a phonic ear. They're kind of an old-fashioned teacher, used to wear the ear device here, and the child would have a FM transmitter, and it would amplify the teacher's voice. And they had a speech and language person come out, and they had tutoring, and they did a teletypewriter in the office and then at home so Amy could communicate with her parents. And they were very happy with that. But they said, we'd like one more thing. We'd like a sign language interpreter. And principal said, no problem, we'll do that. Well, when it came to time for Amy to begin her kindergarten year, they had provided everything but the sign language interpreter. And she said, why don't we have a sign, Amy's mother asked, why don't we have a sign language interpreter? And the principal said, well, our attorney said, let's wait and see how kindergarten proceeds, and we'll talk about it later. And they said, fine. So they went through the school year. Amy was not your typical special ed child. She had 125 IQ. She was one of the most advanced children in the class. She did very well. But because she was deaf, they recognized that she was going to be served under the Education for All Handicapped Children Act, and they decided to have the first IEP meeting for Amy. Toward about a month left in her kindergarten experience, they wanted to write an IEP for when she got into first grade. And when she did get into they did have the IEP meeting, they talked about all these things that they had done, the teletypewriter, the phonic ear, the speech and language person. And then the parent brought up, could we have a sign? We really think Amy needs to have a sign language interpreter. You know, she's a great lip reader, but even the best lip reader maybe gets 60% of what is being said, and as classes get more difficult, she's going to have a more difficult time. So we really believe a sign language interpreter is necessary. And the principal said, well, you know, we have a month left of school. Why don't we do this? Why don't we hire a sign language interpreter for the last 3 weeks of class? And then we will have an IEP meeting and see how it went. And so a young man was hired, came in, you know, as most interpreters do. He was wearing all black, and he was signing for the teacher. And, you know, I've had the experience of teaching college classes with interpreters. It's a very interesting experience because they almost seem literally simultaneously be interpreting what you say. It's quite an amazing experience. But the sign language interpreter called the principal after a week and said, this is a failed experiment. It's really not working. Amy doesn't look at me. She is very embarrassed that I'm there because she knows that I'm there for her. All the other kids really think it's cool to watch me. They don't listen to the teacher. It's just really not working very well. And interestingly enough, Amy Rowley, who is now a professor in linguistics in California, at Cal State, I believe, wrote an article a few years ago called Board of Education v. Rowley, A Personal Perspective, where she, and I think I've sent it to Jolly, so if you ever want it, it's very interesting. And she talks about how she viewed this whole thing from the perspective of kindergarten students. Very interesting. But at anyway, they had the IEP meeting, and they talked about all the things they were going to provide to Amy next year in first grade. And when it got to the sign language interpreter, they asked the fellow, if the young man who had been in and doing signing, how the experiment worked, and he said it didn't work. She didn't even look at me. She didn't want me there. One day she had gone out, teacher left her phonic ear on the, or the phonic ear on her desk. She had taken the phonic ear and thrown it over the fence. She wanted nothing to do with being targeted. So he said, it just doesn't work. So based on that, the school district decided, we're not going to provide a sign language interpreter for Amy. Parents did not agree with that decision. They asked for a due process hearing, one of the very early due process hearings on F.A.P.E, and they lost at the hearing level. So undaunted, what the parents did is they appealed to the federal district court in upstate New York. And as you all know, when there's a due process hearing, the party that loses has the right to appeal to either state or federal court. 99% of the time, attorneys will go to the federal courts because of the idea of being a federal law. And so that's what happened. Parents appealed to the federal district court in upstate New York, and the federal district court overturned the decision of the hearing officer. And this is kind of interesting. What the hearing officer, or what the attorney for the Rowleys, who also happen to be profoundly deaf, held is that this new Education for All Handicapped Children Act requires that school districts provide the best possible education that would allow Amy to achieve to her maximum extent, the maximum extent she could. School district then appealed that decision to the U.S. Court of Appeals for that circuit. And what the circuit court did is they upheld the district court against the school district, saying that, no, F.A.P.E means the best possible education. Education allows the child to achieve to their maximum potential. The school district then appealed to their last court they could, and that's the court of last resort, or the United States Supreme Court. And and I remember I was in my master's degree when they decided to hear the case. And people were worried that the conservative court might just say that the Education for All Handicapped Children Act was unconstitutional. That's not what they did, though. They heard the case, the Rowley case, and one of the things courts do, or the Supreme Court will do, is they will try to not only make the decision, but they will try and give lower courts guidance as to how they can make a decision when they have a similar case on free, appropriate public education. And the first thing the court did is they looked at this law, they looked at the definition of F.A.P.E that I put up a little while ago, and they said, well, it's not exactly, it's kind of a cryptic definition. It doesn't give us a lot to go on, but we still have to figure out what this F.A.P.E thing is. And so in the final analysis, when Justice Rehnquist wrote his decision, he said, we therefore conclude that a F.A.P.E it consists of specialized instruction and related services that are individually designed to provide educational benefit to the handicapped child. And then they developed a test, because remember, the court likes to give guidance to lower courts. And this was the test they developed. It's been called the Rowley two-part or two-prong test. And this test says that there's two parts to it. The first part says anytime a hearing officer or a court examines the issue of is the school district offering a free, appropriate public education, what they will do is they will ask first, has the state, the school district, complied with the procedures set forth in the law? In other words, did they adhere to all those procedures we have in our law? One, that's the first part of the test. Then if they go to the court, or the hearing officer will go, the second part of the test which is this: is the resulting IEP reasonably calculated to enable the student to receive educational benefit? Well, what they did is they took their own test and they applied it to the case of Amy Rowley. And they looked and they said, well, the Furnace Woods Elementary School did a really good job of following the procedures of the law. I mean, they gave the parents sufficient notice of the IEP team meeting. They had all the proper members there. They did an IEP where they filled out all the section, everything they're supposed to include in the IEP was included. So they did a great job of following the procedures. So we say the school district prevailed on part 1 of our test. Then they had to look at the second part of the test. And this is where there was somewhat of a problem. Because as I said, Amy was a pretty bright child. 125 IQ, academically very able. So when they looked at the second part, which is the IEP reasonably calculated to provide educational benefit? Well, they looked at Amy and they said, she's doing very well. She's passing from grade to grade. Clearly, the IEP must have been designed to enable her to benefit because she was benefiting. She was passing from grade to grade. And so the Supreme Court said the school district prevails on point 2. Thus, the school district won in this case and were held to provided a F.A.P.E. One of the things the Supreme Court also did is they rejected the idea that the parents had held that F.A.P.E. meant the child should get the best possible education and achieve to his or her maximum potential. They rejected that idea. And they said, no, it is a basic floor of opportunity, individually designed instruction that allows the child to benefit. And because Amy was benefiting, they said the IEP was in fact reasonably calculated, so they won there. Now, in a footnote to the decision, the Supreme Court also said, but notice, we do not hold today that every child with a disability who is advancing from grade to grade is automatically receiving a F.A.P.E. We're deciding Amy's case, and that's appropriate for Amy. It's not appropriate for every child. Unfortunately, what happened is once that decision came down, courts and hearing officers had some guidance about how to determine F.A.P.E., and they would always, every hearing officer, every judge who ever has decided a F.A.P.E. case has used that 2-part test. And after the Rowley case, a lot more litigation occurred in the area of free appropriate public education, and the courts never had a problem deciding if a school would follow the procedures. Part 1 of the test, courts had no problem with. The second part of the test, courts had a lot of problem with. Why? Because the guidance they got from the Supreme Court was you got to figure out if that IEP is reasonably calculated to provide educational benefit, which in Amy's case was passing from grade to grade, but most special ed cases are not about kids with 125 IQs. Most are about children who have more severe disabilities. And the question courts are struggling with, what is exactly this? What does an IEP, what does it mean for an IEP to be reasonably calculated to provide educational benefits? Well, this is a map of circuit court boundaries. You see, we have all our states there. There you are, Indiana, you're in the 7th Circuit. I'm in South Carolina in the 4th Circuit. Well, what happened after this case is we started to get circuits courts ruling on F.A.P.E. cases, but ruling in different ways, because the difficulty they had with determining what exactly does this educational benefit actually mean for any given child. Well, what happened is some circuits had a viewpoint or took the position that educational benefit, some educational benefit, which is the standard the Supreme Court meant, is a little bit of benefit. Trivial benefit. In fact, the 10th Circuit used the term merely more than de minimis, which meant just a little bit more than nothing. Not a lot of educational benefit, but some educational benefit. But then we had other circuits saying, no, that's not what it means. It means meaningful benefit. It means we have to develop an IEP that confers meaningful benefit for children. De minimis is not enough. It's got to be meaningful. And then we had one circuit that actually ruled both ways. They ruled, see, what circuits do is they have 12 circuit judges on any U.S. Court of Appeals, and they divide them up into panels of 3 because they serve contiguous states, and And like in California, in the Ninth Circuit, which is huge, they have, they'll be up in Montana and down in Arizona. Well, that circuit had some panels saying it means meaningful benefit and other panels saying it's de minimis or little more than nothing. So this is what we had. We had the 2nd, 4th, 8th, 10th, and 11th Circuit essentially saying lower standard, that educational benefit is a little more than nothing, not much, but a little more. We had the confused standard in the 9th Circuit, and then we had the 3rd, 5th, and 6th saying it has to be meaningful benefit. Actually, the 7th Circuit, your circuit, really said had never really actually said what it is. So, but see what happens whenever we get these different standards, and you'll notice that we had the confused 9th Circuit, the Endrew case out of the 10th Circuit, they have very low standard. 8th Circuit, low standard. 7th Circuit is, 6th Circuit is a low standard. 7th Circuit really didn't have one. You can see I'm down the 4th Circuit there, lower standard, but we had the higher standard in the 5th Circuit, the 3rd Circuit, and the 6th Circuit. Now, there's one time, there's only really 2 reasons that the Supreme Court will hear a case. And they don't hear a lot of cases because probably about 8,000 appeals made to the Supreme Court every year. They maybe hear 90 cases, maybe 90 cases. So when they hear a case, it's a big deal because what they say, that's law. That's law of the land. So you see, the problem with this type of model is depending on your zip code, you're either going to be in a higher standard circuit or a lower standard circuit. The Supreme Court doesn't like that. So the number one reason they accept cases is to prevent that kind of problem. Or not to prevent it, but to solve that kind of problem. Because if they announce a circuit, all those are out. It's now the Supreme Court's decision. Whatever they said, all lower courts have to follow. And that's exactly what happened in the Endrew case. Now, Endrew F, the Douglas County School District, was out of Colorado, which is one of those lower standard circuits. And in this case, and I'll talk more about the actual case, but the 10th Circuit said that a school district, in this case, was providing a F.A.P.E because they followed the procedures, part 1 of the test. Part 2 of the test, the IEP did confer meaningful educational benefit, or not meaningful, did confer educational benefit because the education it conferred was merely more than de minimis, a little better than nothing. And that, according to the 10th Circuit, is fine. That meets their standard, therefore F.A.P.E was provided. Well, let me tell you a little more about this particular case. The young man, Endrew, who was called Drew by his parents, was diagnosed as having autism at age 2. Pretty severe autism. He had real language problems, behavioral problems. He was also diagnosed with attention deficit hyperactivity disorder. He was a student in the Douglas County schools through 4th grade, and he had IEPs through 4th grade. When he was out of 4th grade, the parents had been kind of being more and more upset by what they saw going on in the school district with Drew's education, believing that he was not receiving any benefit at all. So what they did is they rejected the 5th grade IEP proposed by the school district. They pulled Drew out of the school district and placed him at a private residential program for youngsters with autism called the Firefly Autism House. Then, and he actually did very well in that setting. Then they went back to the Douglas County schools and they asked for tuition reimbursement, which, as you probably know, I know you know, Tara knows very well, that's kind of the major, that's a major way of addressing F.A.P.E questions. When parents do not believe a school district is conferring F.A.P.E, they can, if they unilaterally place their child in a private school, they could then ask for tuition reimbursement. To receive tuition reimbursement, they have to go to a hearing. The school district doesn't say, no, yeah, we'll give it to you. They have to go to a hearing officer or a court, and they have to prove two things. They have to prove, one, the school district's program denied FAPE, and two, that the private school's placement was appropriate. And so what they did is they said, school district had denied FAPE, and they had particular reasons for saying that I'll talk about. And they also said the Firefly Academy had done a good job, which in fact it had, and the courts, the hearing officers, and even the school district said, yeah, they did a good job, but what they did is the school district denied they said we did offer a FAPE. Well, here's what the parents said. Essentially, they said that the school had denied FAPE. They filed for a due process hearing. The administrative law judge in the due process hearing denied their request for tuition reimbursement, finding that the school district had provided FAPE. So because the school district had provided FAPE then, they didn't even have to look at the second part. Was the private school placement appropriate? Because the school district had provided FAPE. So the parents then appealed to the federal district court, and the federal district court looked at the FAPE issue, and they affirmed the decision of the hearing officer that the school district had provided FAPE. Therefore, parents could not get tuition reimbursement. Parents then filed an appeal with the 10th Circuit Court of Appeals, and if we go back here and look at the 10th Circuit, it's a pretty big circuit. New Mexico, Oklahoma, all those states are in the 10th Circuit. Now, what the 10th Circuit did is they took this case, they had to take this case, and they noted that, again, those two conditions for tuition reimbursement, the school has to fail to provide a FAPE, then the private school has to be appropriate, and they said, well, we don't need to look at the second part, we only need to look at the first part. Did the school district provide FAPE? Here's what the parents said. Parents said that the school district had made the hearing officer and the administrative law judge had failed to recognize that the school district had made two serious procedural errors. Remember, that's part one of the Rowley Test. The first, they said, is the school district had failed to provide adequate reporting on Drew's progress. In fact, they hadn't. The school district said, yeah, we didn't do that good a job, but our teacher did talk to Drew's parents, and therefore, although we didn't formally do the reporting like we're supposed to do, the parents were still meaningfully involved. Second thing the school district or the parents held is the school district did not adequately assess Drew's behavior. Because Drew had significant problem behaviors, the school district had really not done anything. They didn't really have any plan to address it. They had a few kind of punitive things in their IEP, but no really good plan. The parents also said, by the way, there's no functional behavioral assessment, and the IEP did not include an adequate plan to address Drew's behavior. Therefore, they said those are the two procedural errors the school district made, and the ALJ, or hearing officer, and district court failed to recognize. Then they said, there's also some substantive difficulties here. That's the second part of the test. They said, number one, Drew made no measurable progress on his goals. In fact, the goals for his 5th grade IEP were the same goals he had in 4th grade. They just took them from one IEP and put him into the other. And they said there was no progress. His behavior was no better. Academically, he was no better. They said no measurable progress. And then secondly, they said the district failed to address Drew's escalating behavior problems, which were getting worse, and they weren't doing anything about it. 10th Circuit took this case, and what they did is they examined each one of these issues. First, they said, with respect to the procedural deficiencies, the school district had admitted that they did not report progress in the way they should. And the court said, we don't endorse what the school district did, but nonetheless, parents were still contacted by the teacher ever so often, so we ruled that, in fact, that wasn't a procedural error because the parents were involved. So even though they didn't report progress, that was okay because parents were still involved. And then when it got to behavior, and this was kind of a stunning one for me, they cited the law and they said, well, yeah, we didn't do a very good job of, his behavior didn't change. But that's not what the law requires. The law requires, and if you'll read the law itself, the idea, it says, in the case of a child whose behavior impedes his or her learning or the learning of others, the team shall consider positive behavioral supports and strategies. And they said, well, the school district did consider it. They maybe didn't do anything about it, and they didn't have anything in the IEP to address that, but they did consider that, therefore they met that part of the law. So that was not a procedural problem. Now when they looked at the substantive deficiencies, that's part 2 of the test, they said although the school district did not measure Drew's progress, the ALJ, or the administrative law judge, had decided that Drew had in fact made progress because a couple of years before there was some indication that he had progressed. Now, he's not progressing anymore, but he did at one time. And remember, the de minimis standard, according to the Supreme Court, is merely more than nothing, a little bit more than trivial advancement. And they said, well, no, he didn't advance a lot, but he did make that small standard. So the district's Drew's educational progress was sufficient. Also, they said, well, many of his goals remained the same from year to year, but sometimes they changed. So that indicates that there was some effort on the part of the school district to actually prove his education. They also said, again, district made sufficient effort to craft a behavioral plan. They had considered it, so that did not deny F.A.P.E. Well, now the parents are really undaunted and applied for what is called a petition for certiorari to the Supreme Court of the United States. And again, out of 8,000 cases a year, they'll hear maybe 80 cases, maybe 90 cases. So the chances aren't real good that they're going to hear cases unless there's a split in the circuits. And that's exactly, if I went back to that map, is exactly what had been happening. So if Drew had been in the Third Circuit, this would not have been decided that way, in my opinion, because they have a meaningful standard. So here the petition for certiorari went to the Supreme Court on December 2nd, 2015. The parents appealed to the Supreme Court. And what their basis of appeal, they asked one question. And usually Supreme Court petitions, there's one, maybe 2 questions they're asked to answer. The question presented was, what is the level of educational benefit that schools must confer on children with disabilities to provide them with a free, appropriate public education under the IDEA? I remember it being appealed, and I think most people were unsure if they would even hear this case, but because of this split in the circuits, it made it more likely. And then it was December or November that year, the Supreme Court decided to hear the case, which automatically that's a huge deal when the Supreme Court hears a case, because this is the law of the land now. And on January 11th this year, the Supreme Court heard our oral arguments in the case. That, of course, is a picture of the Supreme Court. You'll never see a picture of the Supreme Court with the justices there because they don't allow photography. Very interesting place if you ever have a chance to go. It's fascinating. You see those kind of purple curtains they have in back of them. At 10 o'clock, there's a gong, and they all step out. The justices step out, take their positions, hear the case. It's 1 hour long. At the end of 1 hour, boom, it stops. They stop, and they move on to the next case. Well, this was heard on January 11th, 2017. I had to be in Washington on January 12th and 13th. So I said, I'm not going to have another chance like this again to hear such an important case to special ed. I've got to get there a day early. And so I got a hotel right by the Supreme Court, and I went, because it's interesting when you go to the Supreme Court, you don't get advance tickets. You just line up in the morning to hope you get in. And I had heard, when there's really important decisions, people will literally camp out for a day, sometimes two, to get there. And I thought, well, if I get there at 5 o'clock in the morning, I just hope people aren't lined up. I thought they probably would be, because this is a big case. So at 5 o'clock in the morning, 32 degrees, I went out and waited on the steps of the Supreme Court.
Were you the only one there?
I was the third one in. I was the third one in. And this guy, he's a guy named David Bateman. He's a friend of mine, real law nerd like myself. These two people, Deborah Ziegler and Katie Grady, they're from the CEC, the International Council for Exceptional Children. She's the Director of Policy and Advocacy and does a lot of lobbying for students with disabilities. They were 1 and 2. But it wasn't because they got there before me. When I got there, I was the third one there, and there's 2 other gentlemen waiting there. Well, at about 9 o'clock, so we were waiting, 5 o'clock, 6 o'clock, cold weather. Come about 9:45, they said, line up on the steps. We all lined up, and they let us in at about 9:45. And lo and behold, the 2 guys that was in front of me went, and they were replaced by them. And I said, well, what the heck is this? And it turns out there's professional line standards in Washington that you can hire for $36 an hour people to stand in line for you. Well, I never knew about that. In Columbia, South Carolina, we don't have any professional line standards. I don't know if you do in Muncie or Indianapolis, but probably not. But there's a ton of people, that's what they do, because $36 an hour is not bad for just standing in line. The thing is, if you remember when Betsy DeVos was confirmed? Deb Ziegler made that one too. She waited for, I think it was 20 hours, and there were line standards in front of her. Most of them didn't get in. So people wound up paying $500, $600, but they never got in anyway. Also, if you don't get in, they do something called rush line, where they will say, okay, the next 10, go in for 5 minutes, and they let them go in, and then they shoo them out, and they get another 10. But they're going in 10 minutes time. I wanted to hear the whole case, so I didn't go for that. That's why I got there early. But yeah, I think it was about 50 people were there. It was a fascinating experience. Being at the Supreme Court and listening to the decision and just listening to the justices. And one of the things, when people go to Supreme Courts, and you always hear this on TV, they'll interview someone who's there and they say, well, based on the questioning, this is what we think is happening. Justice such and such will do this. And David and I really listened to what the judges were saying. And 2 of them, Elena Kagan and Ruth Bader Ginsburg, really seemed to be really questioning the representative from the school district. They had some tough questions because it was clear that they didn't believe that the idea allowed de minimis or minimal advancement to be educational benefit. In fact, Ruth Bader Ginsburg said the law needs a standard with a bite, is what she said. So clearly here was 2 justices who seemed to be very favorable to overturning that part of the Rowley Test. Justice Roberts and Justice Breyer both also were questioning the school district representative, the attorney for the school district. And Justice Roberts used the term, and it brought laughter in the court, but he was real serious about it, that you are talking, he pointed to the representative of the school district and said, you are talking about some benefit. And he pointed to the attorney for the parent, and he said, you are talking about some benefit. So he just changed the emphasis in his voice. People laughed and thought, that's quite funny. And Breyer then explained what we mean is, that the school district is saying it's got to be benefit that is meaningful to kids. whereas the attorney for the school board was saying, no, it just has to be a little bit of benefit. So they seem to be very much in favor of upping the standard. And then Justice Sotomayor kind of summed it all up when she said the law really doesn't talk about minimal advancement. I mean, you read the law, you read Article 7, you read the idea, it talks about progress, independence, self-sufficiency, things like that. She said idea provides a clear standard. Our problem is coming up with the right terminology, coming up with the right words. Then the other two justices was Kennedy, and at the time, of course, there were only 8 justices. So a lot of people thought this could end up in a 4-4 decision, which means nothing then. It's like it never happened. But we thought, well, clearly Roberts seems on one side, so we thought maybe a 5-3 decision or so. But amazingly enough, we thought, because I had already decided to talk about the Endrew decision here, and I thought there would be no decision yet, because typically most of the big decisions come down right at the end of the term. So you hear them in May or June. Well, lo and behold, on March 22nd, the Supreme Court made a very important decision in this case, and it wasn't 5-3, it wasn't 6-2, it was unanimous. 8-0 to overturn the de minimis standard. So, and Justice Roberts wrote the decision, and by the way, he's an excellent writer, so it's only a 16-page decision. Very interesting decision to read, but one of the things he said, which is very true, is in Board of Education v. Rowley back in 1982, when the Supreme Court decided this, we did not endorse any one standard for determining when a student is receiving sufficient educational benefit. He noted that, well, with Amy, it was that Amy Rowley, it was she was passing from grade to grade, but that's not sufficient for everyone. But he said that more difficult problem, determining what educational benefit means, is the problem before us today. And the important news is, like I said, it was a unanimous decision overturning the de minimis standard of the 10th Circuit. So all those circuits that I mentioned had lower standards, the 8th Circuit, the 4th Circuit. They no longer have those standards. Their standard, there's only one standard now, and that's the Supreme Court standard in Endrew. So what they did is they rejected the merely more than de minimis. It's kind of interesting. Merely more than de minimis was a term that was developed by the 10th Circuit in a case a couple years before Endrew. And the majority opinion was written by Justice Gorsuch, who's now on the Supreme Court. He came up with that term, merely more than de minimis, who the Solicitor General for the United States used the term. He said merely more than de minimis means merely more than nothing. So essentially what this decision did, it vacated the 10th Circuit decision. That means that, and it's called vacating and remanding. That means the Supreme Court said, 10th Circuit, we think you ruled incorrectly, do it over. So it has to go back. Endrew has to go back to the 10th Circuit. They have to rule again using this new standard, and my prediction on that is they will overturn their old decision, and they will decide in favor of the parents, who will probably get tuition reimbursement because the school district did not offer F.A.P.E. I believe the parents only asked for the tuition they had already paid, but it's very likely that they could wind up, because this was 2 years ago. He's gotten an extra year of education now. And your question's a good one. We actually had a case out of South Carolina called Carty v. Florence that went all the way to the Supreme Court. And I'll talk more about this case a little bit later. But it's a very interesting case. But what happened is, in the lower courts, see, it was the same thing. Often happens in F.A.P.E. cases is the parents will pull their child, unilaterally put him in a private school, and then sue for tuition reimbursement. Remember, a court has to find, one, the school district did not provide F.A.P.E., and two, that the private school setting was appropriate. Well, in this case, in the Carter case, out of South Carolina, I was out of a tiny little school district called Florence District 4 in kind of over by Myrtle Beach area. What happened is this young girl, Shannon Carter was her name, was going into middle school, going into high school, and she's severely learning disabled and only read in a fourth grade, about a fourth grade level. The IEP team met and wrote goals for her that called for her to gain from fourth grade to 4.3 in 1 year's time. Well, the judge in South Carolina, the federal district court, was pretty much outraged by that. He said, that's not growth. That's minimal or de minimis. So he said the school district had not provided F.A.P.E. And where the parents had placed Shannon in a school in Charleston, South Carolina called Trident Academy. And so because the school district had not offered F.A.P.E., they were able to collect tuition reimbursement, which at the time, and this was in the 80s, was $36,000. But that's not even close to the end of the story, because the idea also allows prevailing parties to collect attorney's fees. Tara knows that. Attorney's fees. The Florence County 4 school district, Little Florence County 4 district, was hit with a pretty substantial attorney's fees bill. In fact, it was $1.5 million. Because to go through a hearing all the way to the Supreme Court, that takes a lot of attorney time. And those are billable hours, and that was a lot of money that the school district and then the state had to pay. So there's some pretty big stakes involved in that. But the thing is, that's what's going to happen in this case. They're going to say tuition reimbursement. You know, the parents had attorneys all the way to the Supreme Court. That's going to be a real costly thing for that school district. But let's go on to talk a little bit more about this decision. To me, there's 5 major takeaways from this decision. And by the way, I added a few slides, and Mark is putting them on the website. So if you notice there's slides missing, don't worry. They're on the website. 5 major takeaways, I think, from this decision. One thing is the High Court clearly said the de minimis standard is dead. I mean, the Supreme Court drove a stake through the heart of the de minimis standard. That does not exist anymore. Here's a couple quotes from Justice Roberts' opinion for the unanimous court. When all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. And that a substantive standard, which is again the second prong of the Rowley Test, not focused on student progress would do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act in the first place. In other words, in passing idea, Congress had wanted progress, and to have a standard that's so low, that essentially defeats Congress' purpose, according to Justice Roberts. Then he also said, whatever else can be said about it, this standard is markedly more demanding than the merely more than de minimis test applied by the 10th Circuit. And although for students like Amy Rowley, passing from grade to grade is enough, for most of your students, that's not going to be the goal. For most of your special ed students, the goals are going to be functional goals, more behavioral goals, academic goals, but not passing grade to grade goals. The goals, he said, may differ, but every student should have a chance to meet challenging goals and objectives. And again, he repeated himself, this is more demanding than merely more than de minimis. So that's gone. Now, that standard being gone, what exactly does that mean? I think it means it's going to change the life of attorneys who defend school districts. Because no longer can they say F.A.P.E. was met because we had a little progress. Now they have to say more than that. What is it going to mean to directors and special ed teachers? I don't think as much, because what special ed director, what teacher wants a program, an IEP that confers just minimum progress. We want to do the best we can. But what it really emphasizes in my mind is the importance of the IEP goals, that they be ambitious, and that we actually measure student progress. As Barbara Bateman has said, the same goals year after year, what do they show? They show this is not working because they're not making their goals. So that's almost a red flag now, especially with this new standard, if you don't change the goals. The problem is the goals have to be more ambitious. And that's a lesson I take from the Carter case, is they had written goals that were so unambitious that the court said, that's not FAPE. Child's not going to make, if they make 3 months worth of growth, they're still losing ground. So that's not sufficient. Now, I think what the lesson that gives me is that goals should be ambitious. They have to be reasonable, but you don't want to err on the side of making them so unambitious that a court's going to look at it, a hearing officer is going to look at that and say, that's meaningless, because meaningless is not enough anymore. But I think the real big issue there is we have to be collecting data toward these goals, and if a child is not making progress, we have to change the instruction so they do make progress. So, but let me go on with this. They also said a couple real important things, and the Supreme Court has heard probably, depending on how you count, probably a dozen special ed cases since 1982, since the Rowley case. And in every one, they've always talked about the importance of parental participation, that parents be included in the process. And Justice Roberts called the IEP process, this fact-intensive exercise will be informed not only by the expertise of school officials, but also by the input of a student's parents. And then he went on to say, judicial deference to school authorities. What does that mean? That means that, generally speaking, hearing officers in courts are going to defer to schools because they see the directors and the teachers as the experts in education. So they will defer to them. But judicial deference to school authorities will depend on their having provided parents in the IEP process with an opportunity to fully air their opinion on requisite degree of progress. So in other words, just emphasizing again, it's very important to have parents involved in the process. They also, virtually, probably 4 of the Supreme Court cases that have looked at IEPs, they have really emphasized that an IEP is a FAPE for an individual child. That is the way we develop free, appropriate public education, is by writing a good, educationally appropriate, legally correct IEP. The IEP, according to Justice Roberts, is not a form document. It's not a document that you write and stick in a drawer until the end of the school year. It's something that guides instruction. Also, he said the IEP must enable the child to make progress. Again, I believe, kind of emphasizing the fact that we want to write ambitious goals. We want them to be reasonable, but we don't want to err on the side of being so unambitious that they're not meaningful. And then he said it's through the IEP that a FAPE is tailored to the unique needs of the students. So what he's saying is this IEP is a FAPE. Literally every hearing officer's decision or judge's decision on FAPE boils down to what's in the IEP. And so it's very important how we construct and develop IEPs for the students with whom we work. They also said the IEP must aim to enable a child to make progress. After all, the essential function of the IEP is to set out a plan for improving academic and functional advancement, or pursuing academic and functional advancement. Really, again, emphasizing the fact that IDEA is not just about academic achievement, it's about functional achievement. It's about communication, behavior, whatever issues the child has, that we also have to address those. So that's my number one takeaway, is de minimis is dead, the new standard is progress. Here's the second one. This progress standard is not maximization. The court rejected the maximizing standard, like they did in Rowley. They said it's not our task to develop the best possible education, or even an education that confers maximum benefit, they said, how do we determine what maximum benefit is for any child? Our task is to develop an IEP that confers progress, but not necessarily maximal progress. In fact, he noted that the Rowley court had specifically rejected the parents. Remember, Amy Rowley's parents had said, should be best possible education that maximizes her ability. Rowley court had rejected that, and the Endrew court also did, essentially because they said, it's just too difficult to determine. You can't determine what maximum progress is. We do have to definitely develop progress, but it doesn't have to be maximum. They said, we decline to interpret F.A.P.E. in a manner so plainly at odds with their decision in F.A.P.E. So, again, it's progress. It's not maximum progress. It's what a U.S. District Court judge called a Cadillac. Not a Cadillac, but a serviceable Chevy. You probably, I know you've heard that. In a case in Oklahoma many years ago, out of Oklahoma, called Oklahoma City School District v. Tullahoma, it was a F.A.P.E. case. The parents wanted maximal progress, and they said, the judges wrote in their opinion that the parents want a Cadillac, but all the idea really requires is a serviceable Chevy. They don't require the best possible education, but they require a meaningful or a education in which a child progresses. And now, certainly, the Supreme Court is saying not a junker. You know, it has to be real progress. But nonetheless, still, I don't believe schools are not going to be held to those higher standards, but they are going to be definitely held to an elevated standard. This Supreme Court said, to meet its substantive obligation under the idea, a school must offer an IEP that is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. That, in essence, is the ruling of the Supreme Court. The school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Third major takeaway I have from this decision is that it doesn't overturn Rowley, it complements Rowley. So in essence, we now could say F.A.P.E., the test of F.A.P.E. that every hearing officer, every judge is going to use is really now the Rowley-Endrew standard, because the first part is still there. The first thing a court is going to look at is this: what did the school district comply with the procedure set forth in the idea? The second part, which is from Endrew, is this: is the IEP reasonably calculated to enable the student to make progress appropriate in light of the student's circumstances? In my opinion, we're probably going to see a lot more litigation, F.A.P.E., because people are, attorneys are going to be trying to test this standard to see what it really means. Clearly, if we go back to what the court said, they said it clearly means more than de minimis. So that is dead. That's gone for good. But what exactly does that make progress appropriate in light of the student's circumstances mean? And that's my fifth major takeaway, or fourth major takeaway, is the full implications. We're not going to really know until we get more court decisions and hearings on what exactly that means. But note this: courts will be following the Supreme Court, and no attorney, or if there should be going to court and saying, well, we offered a little bit of education, we offered de minimis, because the court will not accept that. So if an attorney's telling school district people that, they need to get a new attorney, because that's not the standard anymore. The standard is progress, and what you say is exactly right. What is the degree of progress? Well, think back to what Sotomayor said. She said, the trick is coming up with the right words. Those are the best words that the Supreme Court could come up with to elevate the standard, but still not go all the way to maximization. But we'll just have to look. We'll have to see what happens in the courts. There have also already been 5 or 6 decisions that have taken applied the Endrew standard, and the majority of them have said it's more than de minimis. Every one that I've read has upheld the lower courts, which used kind of a higher standard to begin with. So we'll just have to see what happens now, especially like what happens in the 10th Circuit. When that 10th Circuit looks at Endrew again, what are they going to do? I think clearly they're going to overturn their old decision. Now, this is one of the last important things that we have to understand about this is what exactly are the roles of hearing officers and judges? Now, Justice Roberts wrote, we're giving a standard, we're not giving a formula. So that kind of gets to the question about what exactly does that mean for any given child? It can only be decided on an individual basis, using what the Supreme Court did. So they said, here's your standard. You have to determine, did that IEP, was it calculated to provide progress? Did the child actually make progress? You know, if there's any one thing that has impressed courts over the years, it's when a school could show progress with real data. In fact, there was a decision out of Ohio a few years ago in which the school said we made progress, and they had all the IEPs that said made progress, check, made progress. They said that's not sufficient. You need some objective measure of progress, data, in other words, to show that a child is progressing. And if you can show progress, I mean, if you have data to show progress, you have an unassailable IEP, in my opinion. As long as the goals were ambitious, they weren't so minimal that if they made the goals, they wouldn't benefit. So I think, and this kind of leads to the fifth major takeaway I have. But I do want to say that the Supreme Court did say we're not attempting to elaborate what appropriate progress will look like in any given case. The adequacy of a given IEP turns on the unique circumstances of a particular child. That's the only way you can determine that. Look at the IEP, look at the child's needs. But again, and I put this up before, but I think it's very important, a reviewing court may fairly expect those authorities to be able to offer a cogent and responsive explanation for their decisions in the IEP, the goals, the progress monitoring. For their decisions, it shows that the IEP is reasonably calculated to enable the child to make progress appropriate in light of his or her circumstances. Now, my major fifth takeaway is this decision provides clear guidance to special ed administrators and teachers in developing IEPs that meet this new standard, that meet the Endrew standard. And here's what I think the message of this decision is. The message is not so much that we've got to change practice. The message is just we've got to do what we know is right. We have to keep doing the best we can do. We have to conduct relevant assessments of all of a child's needs that address all of the needs, irrespective of disability, and essentially serve as a baseline for our goals, because that's where we start. If we don't have information where the child started, we can't show progress. So we need that baseline data. We have to develop measurable annual goals that are ambitious but reasonable. We don't have to develop goals that are so ambitious that it's unlikely a child's going to meet them. That doesn't make sense. Would have made sense in the case I was talking about, the Carter case, where they said, well, she'll make growth from 4.0 in reading to 4.3 in 1 year's time. That's very unambitious. But we don't want to say she's going to be going from 4th to 8th grade reading ability in 1 year. That's not going to happen. But we've got to err on the side of ambition. And I've heard, when I present, I've often heard teachers say, but we don't want to write goals that the child won't reach because we're going to be in trouble. We're going to have trouble. No, you won't. you won't have trouble. IEP is not a guarantee of success. It's a guarantee that we're going to make good faith efforts to meet those goals, and we're going to measure those goals, but it's not a guarantee that a child will make the goals. It's just a guarantee we'll provide all those services we said we'd provide. So I think second major takeaway is, in terms of special ed administrators, teachers, we need to make certain our goals are measurable. Now, one of the things I've been doing for the past, I don't know how many years, is we had a grant one year to develop an instrument that would allow school districts to assess the kind of substantive quality of their IEPs. And so we looked at thousands of IEPs. Most goals we found were not measurable. You couldn't measure them. They were things like, Stacy will make friends and things, not measurable things. We have to emphasize goals that are measurable, that are visible, have real objective criteria for meeting. And I know the IEP Resource Centers, their webpage is filled with information on developing measurable goals. That's extremely important now. Write goals that are measurable, ambitious, but reasonable, and also, when you write those goals, make sure you monitor them. Make sure you collect what the court in Ohio I was talking about said was using objective data instead of subjective opinion. And I've talked about this particular case here before, but it was IEPs, 2 years of IEPs were thrown out by the court. They said they're invalid because they weren't measurable and because they contained things like that were basically someone's subjective opinion that the goals had been made instead of collecting some sort of data. That, I think, is more important than ever. But we actually have to monitor. It's not enough to write measurable goals. We also have to measure them. We have to report, what the law says is frequently, as you say, general ed kids get report cards on progress toward each goal. And we have to use legitimate data to do that. And very importantly, if a child is not progressing, we don't just repeat the goal, we make an instructional change and continue to collect data. And if we can show progress, we've done everything the law requires of us. So I think that's the clear message for those of us who teach. Because, as I said before, no teacher in the world or special ed director ever wanted to just confer a minimal amount of progress. We always want to do the best we can. We just have to make certain that we can objectively show that we're monitoring progress. And a child, in fact, is making progress. Now, if you would go to Google sometime and write SCOTUS blog and Endrew, you will come to this page, because the Supreme Court has a blog called SCOTUS blog, the official Supreme Court blog, that is fascinating. This is just a screen capture, but you can get the decision here. It's a real fascinating decision. You can get the 10th Court's decision here. There's a woman named Amy Howe who writes the blog. There's a section on, she has on the argument analysis, what the court was saying, what the ruling means. And this down here is really fascinating, because this section is where they put proceedings and orders and friends of the court brief. And there are about 15 friends of the court briefs that were written in this case. They're really interesting to read. The most interesting to read is there's one that'll say, amicus brief from the Solicitor General of the United States. Because why that is so interesting is that is the position the federal government took on Endrew. They took the position that the 10th Circuit should be overturned. And that's one way you can tell that a lot of us, we read this, when Supreme Court asks for an opinion by the Solicitor General, you can bet the farm that they're going to hear that case, because they want to know how the U.S. government comes down on the case. And they had a very strong argument that really the Supreme Court accepted, pretty much in whole, the decision that they came up with was more actually from the Solicitor General than it was from the attorneys for the parents. So, but go to that page, very interesting. It's called SCOTUS blog. Now, the next thing I want to do, does anybody have any questions about that decision itself? Want to talk about that a little more? The Supreme Court will often do that. Now, in the Rowley case, they just overturned the decision. In this case, they decided to do what they called vacate and remand. He just said, what you decided before is wrong. We have a new standard. Now here, decided again using our new standard. So essentially, they're saying, you got it wrong, you got to get it right, but we're giving you a chance to do it, sort of. Yeah, now, so they're going to have to go by this new standard, appropriate in light, or making progress in light of the child's circumstances. You know, it's going to be interesting to see how they rule, but what's really going to be interesting is seeing how courts begin to interpret this decision. Also, what I want to talk about from this decision is the IEP, because the Supreme Court in this decision, remember, talked about the IEP as being this fact-intensive exercise. They've used terms before like the centerpiece of the idea, the modus operandi of F.A.P.E. The IEP is extraordinarily important because every F.A.P.E. case comes down to what was written in the IEP. And so if we look back and we take Rowley and Endrew together, there's certain things we have to understand. There's a procedural dimension to the idea. That is all those little things that we have to do. They sometimes drive people crazy, but we have to do them because that's what the law requires. You know, we have to make certain we send our notifications to the parents to give them enough time to be involved. We have to, if we determine that we're going to change something in a child's education or placement or evaluation, we have to send prior written notice. We have to get an IEP team that's composed of certain people. You know, the general teacher, the special ed teacher, the LEA rep, all those folks. Those are kind of the procedural requirements we have to make certain that we follow. Julie Weatherly, who's an attorney who represents school districts in Alabama, refers to when we make errors in the procedural area, and that's the first prong of the Rowley test, she calls those process errors. Then there's a substantive. This is the part that really changed with Endrew. That's the second prong of the Rowley test, which is really now the Endrew test, that a child must benefit. But that has to do with the actual content of the IEP. That has to do with developing an IEP that confers meaningful educational benefit. And I put meaningful in quotes because the Supreme Court didn't say that, but in essence they said de minimis is not enough. They didn't go all the way to maximum, but they found something in between, which they just called progress appropriate in light of a student's circumstances. But the way we meet that test is by developing an IEP where we do all those things we just talked about. We conduct a relevant assessment of all of a child's needs, and that becomes our present level statement or the baseline. Then we develop measurable annual goals that we believe will confer, if the child makes goals, meaningful progress. So that's a 1 year's prediction, and we want to err on the side of ambition. We want to be reasonable but ambitious. And then third, we have to measure those goals, report on a child's progress, and develop a program of special ed and related services, and make certain those services address all of a child's needs and deliver them as written. That's the substantive part. That's what Julie Weatherly calls the content stuff. So if we make errors like our goals aren't measurable, those are content errors. Those are a lot more serious than procedural errors. In fact, in 2004, Congress changed the procedural dimension a little bit. They said procedural requirements are important and must be followed. However, failure to follow all the procedures of the law will not always mean you're not denying F.A.P.E. If you make an error that essentially, but the child still progresses, that's enough. In other words, the substantive is more important than the procedural. The part about the goals being ambitious and measurable and that we measure them, that's the important part. They said, what Congress said is the procedural violations will only result in a ruling that F.A.P.E. was denied if those procedural violations essentially cause a deprivation of educational benefit. Say we didn't follow the procedures and we didn't do an appropriate assessment of all of a child's needs. That could be said to be a procedural mistake, but that procedural mistake's the bad one, because if we don't address all a child's needs, the IEP will probably not be appropriate and not provide F.A.P.E. So that would be a procedural error, a very serious one. But the most serious one of all, according to Congress, is any procedural error that we commit that significantly impedes a parent's right to participate. Well, what does that mean? That means whether there was just a case out of the Ninth Circuit, out of Hawaii, where a school district called a parent, it was called Doug C. v. State of Hawaii. Parent was Doug C. The school district called him and said, we need to have an IEP annual review because the IEP is close to the end of the year. We need an annual review. The parent said, oh, great, I want to be there, but unfortunately I can't make it next week when they were trying to schedule it. So could you reschedule it for me? And they said, yeah, we can reschedule. But what happened, there was a little mix-up in understanding, and the special ed teacher called the Doug C. the night before and said, we'll see you tomorrow at our meeting. He said, but I can't be there. And they said, oh, okay, let's reschedule. But we got to do it real quickly before the year runs out. And what happened is they rescheduled. The night before, the 2 days before the meeting, the father called and said, I'm sorry, I'm ill. I can't make it. Could you reschedule? And the special ed teacher said, I have to get to the special ed director about that. And the director said, no, you can't reschedule. You've got to do it now. And so they held the IEP meeting. The parent was really upset. And in the long run, what eventually happened is actually went all the way to Ninth Circuit Court, and the court said they denied F.A.P.E. because they didn't involve the parent. And the parent wanted to be involved. And it would have been very simple to reschedule, but they decided not to do that. Now, that doesn't mean you can't go and do an IEP meeting without the parents. You know, I was a teacher of youngsters with emotional behavioral disorders for 16 years, and there was a lot of times we had IEP meetings. The parents, they didn't want to come, or we couldn't find them. And that's okay. Then we just have to go on and do our job and do the IEPs, but we want to make certain we document that we made all those good faith efforts to try and get the parent involved. What this harmless error doctrine says is that is not a harmless error. If we don't involve the parents, that's a biggie. And because that's what the idea is based on. It's based on a collaborative development of programming. So you've got to make sure we really make good faith efforts to involve the parents. Now, what I mean by harmless error is, let me use a kind of a silly analogy. Let's say you're watching a football game and Andrew Luck tosses a pass into the end zone, and his receiver goes up, and the defensive back, the cornerback, tackles him a little early, and he doesn't get a chance to catch the ball as a result, but Andrew threw it five rows up into the audience. It probably wouldn't be called, because that's a harmless error. He threw it in such a way the guy couldn't have caught it anyway. That would be a harmless error. That's what a lot of the errors in IEP development are, except for these three. Now, to further stretch this analogy, let's say Andrew Luck threw it, he could throw it all the way over the stadium. If the defensive back had grabbed the receiver's face mask and pulled him down, that would be called, because that's a serious error. That's what these three are, serious errors. But nevertheless, we still have to follow procedures. But the important thing is the substantive. getting that part right, getting those present level statement writing our goals that are measurable. The substantive or content errors are critical, and those are the ones we really want to avoid, especially with this new Endrew standard that's saying we have to confer benefit. That's the way we confer benefit, is writing ambitious IEPs and then measuring them and making certain we implement them as written. So those are what Julie Weatherly calls the content errors. Now, we have a whole new type of error we're seeing come up in the courts, and it's a third F.A.P.E error, but the Supreme Court didn't address it, and that's what we call the, we talked about these already, that's what I would call the implementation. We have seen a number of cases in which school districts had done really good IEPs, and they were ambitious, they were procedurally correct, but parents have gone to hearings and saying, yeah, they were a great IEP, but they didn't implement it. We're seeing a whole bunch of cases starting now where courts are looking at that as a third major dimension of F.A.P.E. So Rowley Endrew looks at the procedures and the substance, but the new cases are looking at implementation. And essentially, in many, what they're ruling is that you could have the best IEP in the rule of most, the best IEP in the world, you could have developed it using all the correct procedures, but if you don't implement it, you're still not providing F.A.P.E. Now, Perry Zirkel is writing an article for a journal I edit on, there seems to be developed kind of three approaches that courts are looking at in determining the implementation dimension. So what I want to talk about now is how we now are looking at not just procedures, not just substance, but implementation also being part of a F.A.P.E, which essentially means what we write, we have to do. If it's in the IEP, we have to honor it. We have to carry out the provisions of the IEP in terms of the special education and related services. Now, this is what Perry says. There's essentially three major types of decisions about implementation. The first implementation he calls the material provision or educational benefit and educational benefit approach. And this is primarily in the Fifth and Third and Fourth Circuits. What they're saying, now note that doesn't really apply to you because you're in the Seventh Circuit, but because you don't have a decision yet, hearing officers are going to have to use what is there, and so they might be looking at this. There's two parts to this test. The first part is, say a parent says that you did an IEP, but you didn't implement it, or you implemented only part of it. And that goes to a hearing officer. What are they going to do? Well, according to the Fifth and the Third and the Fourth Circuit, they're going to apply a two-part test. Remember, courts love these different tests. And the first part of the test is they're going to say, did the school district fail to implement a substantial or significant provision of a student's IEP? In other words, was there a major thing in the IEP that you just kind of forgot to do? You know, I was talking yesterday to a speech and language person, and she was saying that she was worried because she was saying, well, you know, sometimes we have snow days and I can't get, the school is called off, and as a result, some of the kids I can't provide the service on that day. Well, that's probably not a really significant error. You just can't. You miss one day, you miss 2 days of speech and language, probably not a big deal to a hearing officer. You miss half or a third, yeah, that's a big deal. And that's what that means, material provision. Or say, you know, we have to be very specific when we say, when we write our services, we have to say where they're going to be offered, what the duration is, the location, the frequency, all those kind of things. Say we have reading 5 days a week, 1 hour a day, and we miss it for 3 weeks. That's a big deal. But courts have to figure that one out. What is a big deal and what isn't a big deal? And then, say a court says, yeah, they made a substantial error. The second part of the test is, well, did the student receive educational benefit? And if they did, well, maybe that error wasn't that big a deal. But that's what the Fifth, Third, and Fourth Circuit say, but the Ninth Circuit has a different view. Here's what they say. In a decision in this case down here, Van Dyne v. Baker School District, they said, we hold that a material failure to implement an IEP violates the idea. So again, that idea, the notion that, is it a big deal? And if a material failure occurs, when there's more than a minor discrepancy between the services a school provides to a disabled child and the services required by the IEP, that's a violation of F.A.P.E. The Ninth Circuit said it doesn't even matter if the child benefits. If you're not providing the services you said you'd provide, that's a material violation. We're not going to even concern ourselves with, did the child benefit? We're going to say, you messed up because you didn't provide a major aspect of the IEP. Now, the third, which is also out of the Ninth Circuit, I think it's a better way to understand this, is the Ninth Circuit has now said, think of the IEP as a contract. And they use that term. They said the IEP is a contract. Because the IEP is a contract, any deviation from it is an automatic denial of F.A.P.E. Because if you know contract law, what contract law says is, you have a contract, if you violate any provision of it, you violate the contract. That's what the Ninth Circuit said this year. IEP is like a contract. If we don't make certain that it's implemented as written, we're in violation of the contract. And remember, the Ninth Circuit said, doesn't matter if child benefits. You may, if you violate a contract, that's a big problem. So, now look at what we have. We have 3 circuits saying one thing, another circuit saying another thing. What does that mean? Who is likely to hear a case when there's a split in the circuits? The Supreme Court. So I think this may be the next big deal on the F.A.P.E. landscape, may be the question of implementation. With what degree of fidelity are we implementing our IEPs? And they're all saying, and the Ninth Circuit is saying it's like a contract. The Fifth Circuit and somewhat the Third and Fourth are saying, well, it's like a contract, but if it's only a minor thing, that's not a big deal. But they're saying it doesn't matter if it's anything. So I think that's going to be the next big thing. This is a really interesting dissent in the one case, and I'll read it. You probably can't read it. But the dissent in this particular case said, judges are not in a position to determine which part of an agreed upon IEP are or are not material. So in other words, he was saying what the Fifth Circuit said about, is it a material or a big deal? He said, judges shouldn't be in the role of making that determination. That's up to the IEP team. Because if the IEP team that consists of experts, the school district personnel, the teachers, the parents, they're the folks that should determine what's appropriate. They put it in the IEP. That's the contract. That IEP. Judges shouldn't be saying, well, wait, did they violate a material part or a non-material part? So what they're saying is essentially is judges should not be involved. They should go to the contractual approach that says if there's anything in there you don't honor, you have a real problem. So that I think is the next issue we're going to see. And we're going to see a whole bunch of cases, I think, on the issue of the Endrew, but I think we're going to start seeing more of these too about implementation. Because what this court is saying is, again, it doesn't matter if the child benefited or not. If you didn't implement the whole IEP, you didn't honor your contract. So it's important to understand, though, I think, the IEP is like a contract in that we're listing those services that we'll offer. That's the contract part. An IEP is not like a contract in that we're contracting to meet these goals. Because remember, the IEP is not a guarantee of success. It's a guarantee that we're going to make good faith. We're going to do the best we can to develop an IEP that is going to confer benefit. But if the child doesn't meet the goals, that is not the contractual part. The contractual part is we'll make good faith efforts and we'll do all those things in the services that we said we'd do. Now, so this is what these decisions look like so far. These courts, the 5th, the 4th, and the 3rd, are saying in terms of IEP implementation, what a court needs to look at is a material failure. If you failed to implement a material or important or substantial part of the IEP, that's a problem. But we're also going to look at benefit. Did the child benefit? And then this court is saying it's like a contract. We're going to look at the IEP and we're going to say, did they honor the IEP or not? Doesn't matter if the child benefited. We're just going to look at the IEP. So, see, we're already seeing a split in the circuits. 7th Circuit having most circuits have no decision at all. So this is what that means is this is an area of law that I think we're going to be seeing a lot more activity in the future. And if this kind of split continues, that makes it more likely the Supreme Court's going to hear it someday. Now, what this means is we have to ensure that all special education related services and program modifications, services part of the IEP, that we write into the IEP, we have to honor those as written. You know, I've seen IEPs that'll say things like, where it talks about the special ed services, the frequency, the duration, the location, will say things like, as needed. That's not probably okay. You know, you have to be much more specific about that. But once you have those written in, make certain you honor them. We want to increase the likelihood that implementation is accurate, that everybody's on the same page. And I know you have the IEP at a glance. That, I think, is an excellent way. It's a more practitioner-friendly way to boil the IEP down into kind of simple areas, into the major areas. You know, I remember when I was teaching, our principal always told people that you would send notes to teachers. We just had an IEP on such and such student. Go to Mr. Yell's room, get the IEP and read it. Well, how likely was that to have happened among general ed teachers in a middle school? Didn't happen. So the results were that oftentimes we had provisions of the IEP, especially those that involved general education, that never got implemented. That would be a violation of this implementation dimension. So we want to do whatever we can do to increase the likelihood that of accurate implementation of our IEPs. One way we can do that is through like your IEP at a glance, because it's a real practitioner-friendly way to outline those personal responsibilities. And I think teachers should understand and sign off on their responsibilities, especially when you have a lot of teachers that have to implement certain aspects of the IEP. Now, this is just an example I did with some of the school districts I work in South Carolina, especially where we have in middle school and high school where we have a lot of different teachers. And what we did is we developed a form where it would say the student's name. We'd put, John Long down, the teacher's name, the date, and the specific program modifications that we required for the student. For instance, modification. All tests will be read to John by a peer professional or teacher. So if that's a modification you put down in the IEP, you want to make sure the teachers are all doing that. So put that down. Maybe say we had a child who is on a check and connect program. Modification all teachers have to do is they have to fill out a check and connect form. So we could put that modification down. Explain it to teachers, have them sign it, date it. Make certain that they're actually implementing them. Because in this new line of cases that I think we're seeing on implementation, if we're not implementing all of the IEP, including modifications to the general ed, which tend to be the most likely to be not implemented, we could have some real problems. And let me just spend a little time talking. There was a case out of West Virginia. And this is not a typical case by any means, but it illustrates the importance of making certain we do all those modifications we write in the IEP. There was a case, it was quite a while ago actually, 1997, in West Virginia called Doe v. Withers. I don't know if people have heard of that case. Have you heard of that case? It was, and I think the important message of that case is not that, not the eventual ruling in the case, but the fact that a modification was put in the IEP and wasn't honored. It was a case involving a young boy named John Doe. The court name, his real name wasn't John Doe. That's what the court named him because they usually don't use names of kids under 18. You know, they'll say like Endrew F. They never gave his last name, or sometimes John Doe. Well, John Doe was in middle school, first year in middle school, severely learning disabled, had an IEP, read on, it was like a primer level, really, really low reading ability. Did pretty well in his classes. They had an IEP meeting for John, and they had the special ed director there, the principal there, the special ed teacher there, and they had the health teacher, the science teacher, and the social studies teacher, and of course, John's parents. And during the IEP meeting, the health teacher said, you know, John's really good in class. Excuse me, the science teacher said this. John's really good in class. He loves to talk about science. He participates. He does a great job, but if I give him the tests, he's going to fail because he can't read. So what I do is I have one of my better students in the class go out and read the test to him. And so I make certain that all tests that John has to take, he's read. We read to him. And the team said, that sounds like a great program modification. We'll put that in the IEP. All tests from science, health, or social studies in English have to be read to him. And so wrote the IEP, everybody signed the IEP, went away happy. At the end of the first semester, John came back with his report card. Showed his parents the report card, health A, science A, math A, English A, social studies F. And he said, what happened in social studies, John? You loved social studies. You know, this semester you were studying Greek and Roman history, and you came back and you talked about it every day, and the teacher always had good reports. How did you fail that class? And John Doe said, well, Mr. Withers wouldn't read the test to me. And parents were quite outraged. They called the principal. They said, could we have everybody get together? We want to talk about what happened in this IEP, because the social studies teacher didn't read it, read his test to John, and he failed. So they had a meeting, and they confronted the social studies teacher. Why didn't you read the test to John? That was in the IEP. And John Withers said, well, I treat everyone the same in my classroom. My classroom is a level playing field. Everyone's treated the same. Apparently not understanding if you can't read, you're in a real unlevel playing field. And the idea of reading the test, that levels the playing field. And so he said, I treat everyone the same. I was not about to do it because that's the way I roll. And so the parents were pretty upset. They filed a lawsuit. But they didn't sue under the idea, which they could have done. What they did is they sued under a law called Section 1983 of the Federal Criminal Code. It was actually a law that was passed in 1865 right after the Civil War. And the law says if you're acting under color of state, which means you're a teacher, you're a principal, you're a policeman, you're a fireman, somehow you're paid by the state, you're really acting under color of state. If you knowingly violate a federal law, you can be held personally liable for that violation. Well, the parents went and sued everyone. Special ed director, special teacher, principal, everyone. The judge threw everyone out except one, the case against John Withers. He let it go to a jury trial. And what the jury had to determine was, did John Withers, was he a teacher? Did he act under color of law? Yes. And then they had to determine, did he knowingly violate a federal law? And they said, well, ideas of federal law requires the IEP. The IEP must be followed. He knowingly didn't follow the IEP. Therefore, he violated Section 1983 of the Federal Criminal Code. And the judge fined him $25,000. And that the ruling is not important. I mean, yeah, he had to pay for it, but that's not going to happen very often because most attorneys are not going to go after individual teachers because we don't have deep pockets in most cases. What they do is they'll go after school districts. They can't, you know, there's one thing in idea that you can't collect. You can collect attorney's fees, you can collect tuition reimbursement. Can't collect punitive damages. No punitive damages. You know, punitive damages are what attorneys really like because that's where the money is. Because the whole idea of punitive damages, we're going to find John Withers and he's going to learn his lesson. He's not going to do it again. But $25,000 to most attorneys is not a big deal. So they will go after school districts because that's where the money is in attorney's fees or provisions. But think about this. If that case had been an implementation case, clearly there was a major part of that IEP that was not being implemented. That school probably would have lost. And they would have been on the hook for attorney's fees, probably compensatory education. So that's a big deal that we make certain we're implementing things just as they're written. You know, again, that dissent said it. We're the experts. We get together. We craft an IEP. We do so because we believe that's what's necessary for a child to receive a F.A.P.E. And if we don't implement it, we're violating a contract. So that's just a real, I think that's going to be the next level of cases. So kind of add that whole implementation piece because that's a big deal. And I think we're going to see a lot more of those types of cases. So, does anybody have any questions about that? What I want to do in our last time then is I want to talk about, I want to kind of go back to Endrew a little bit and talk about what I call the unlucky 13. And that is the 13 procedural and substantive errors and implementation error that we really need to avoid given this new decision. Now, the procedural errors, that part really hasn't changed since the Rowley decision, so that's still the same as ever. It's the substantive, really, that are starting to change. And so we'll go through the procedural errors real quickly, and you all probably know what they are. This is the most common procedural error, which has not changed since 1975, is failing to provide parents with prior written notice. For some reason, that is still a big problem. You know, and a friend of mine and myself have been looking at, and not all states publish their compliance issues they're having with school districts. Some states do. South Carolina, we do to some extent. But the number one decision we're finding in our state and other states is so often listed in compliance problems is just that. Failing to provide prior written notice. And I think you all know about prior written notice. Anytime we make a change in a child's evaluation, education, placement, we have to give prior written notice. We have to take that form that you all have and we have to make certain the parents get it. Because prior written notice essentially allows a parent to say no. One of the things we do, I know you guys do it here, is IEP facilitation. We do that in South Carolina too. And at one time I was an IEP facilitator, then I became a hearing officer, now I'm a state hearing review officer. But when I was an IEP facilitator, I would go to school districts and I'd see this being not done when it should be done so frequently. I still recall going to one IEP meeting where the parents requested extended school year services. Now, prior written notice, has to be done whenever we propose, to make a change, but also when we say we're not going to make a change. So if the parent requests a change in placement, evaluation, all those sorts of things, programming, we choose not to make it, we have to do prior written notice. I was at an IEP meeting doing a facilitation when a parent asked for extended school year services. And the principal of the school said, no, we don't do extended school year for anybody, so we're not going to do it for special ed kids. Well, that's a mistake in itself. That's a huge mistake. You can't, you can do that, but you better not do that. But at least the team should have discussed it. Now, they could come to the decision, consensus of the team, that we're not going to provide extended school year services, but they would have had to done prior written notice and explain why they weren't doing that. But they didn't do that. Principal said no, and they never did prior written notice. So, huge mistakes. Prior written notice. Another one, simple mistake, but is failing to obtain parental consent. Those are procedural type things. But they're bigger procedural things because these two errors can involve can lead a hearing officer or a court to say you're not involving the parents. So that's a big deal because remember the harmless error doctrine. This is another big deal. That is improper IEP team membership. This is a decision out of New York. It was a hearing in New York where a school district was found to have violated IDEA because they didn't include a general ed teacher on the IEP team. And the hearing, the state review officer said an IEP prepared by an invalidly composed IEP team is a nullity. So we have to make certain, especially for those initial IEPs, that we have the entire team there. Failing to ensure parents' meaningful participation in the IEP process is the procedural error that's as close to, I guess you'd say, the hanging offense as anything. That's a bad one if you do anything that doesn't involve the parents. Now, that doesn't mean we can't do an IEP unless we have the parents there. If we can't contact the parents or they don't want to be involved, as long as we make and document those good faith efforts to contact and get the parent there, and in our state we have a regulation that says you have to do at least two, and I think you do have a similar thing, 2 methods at least twice. In other words, we have to make 2 different types of, try to contact the parent in 2 different ways at least 2 times. If that doesn't work, go ahead and we do our IEP meeting. But make certain you document it. You know, the saying in real estate is location, location, location. But lawyers will say the big thing is documentation, documentation, documentation. So if you have to go ahead and hold a meeting without the parents, as long as you've made those good faith efforts to involve them, make certain you document that, go ahead and hold a meeting. Another procedural error that's a killer, predetermination. Predetermination refers to any time that a school district is seen to decide a student's placement or program before they meet with the parents. That would be predetermination. That is something to be avoided. Now, that doesn't mean that you can't have meetings before the parents come. It just means you can't make final decisions without the parents' involvement. So there have been a number of court decisions where parents have held a case of the school district predetermined the placement or the programming because they had meetings before we got there, and the school district has, courts have often said, well, as long as the school district kept off making any decisions until the parents were there, that's fine to have pre-meetings. It's fine to do a draft IEP. You just don't make your final decisions without the parents, unless, again, you have tried but failed to get them involved. By the way, there's an attorney named Jim Walsh out of Texas. You probably heard him. He speaks a lot. One of the things he has said, is that, and this is often true, oftentimes, I don't know what, I never actually talked to Jolly or Matt about this, do you folks take notes at IEP meetings? Yeah, okay, yeah. It's, we have a situation. In South Carolina, half of our special ed people say take notes, the other half say don't take notes. So pretty much everybody takes note because the attorney for the for the State Department has said, take notes in a meeting. That's what Jim Walsh says too. And I have read more decisions in hearings and in court cases that have turned on the quality of notes that the school district takes, especially when predetermination is involved. And what Jim Walsh says, and I won't go through all these, is notes taken at an IEP meeting are very important. In fact, Slater, Weatherly, and Walsh, those are three pretty well-known attorneys in special ed, all suggest take notes at the IEP meetings. When you take notes, I always tell people that think of yourself as Ernest Hemingway, not William F. Faulkner, which means you write, don't do stream of consciousness notes, just hit those main points. Those main points are those times the parent is asked for their opinion, that they give their opinion, that you discuss certain issues that may be contentious. And I've listed a number of examples that Jim Walsh talks about of good documentation. And so you don't need to copy these down, or we don't need to talk about those. But he says making certain your notes are really concise and just hit those big points. But a lot of cases have turned on notes. And you remember, this is one of my favorite rulings ever in a court case. It involved predetermination. The parents held that the school district had failed to provide them meaningful benefit because they had informal meetings before the IEP meeting. And the court looked at the IEP meeting, looked at the notes in the IEP meeting, and clearly the parents were involved. And he said, well, the final decisions were made at the IEP meeting, and they ended with this statement: school officials must come to the IEP table with an open mind. That doesn't mean they need to come to the IEP table with a blank mind. And so essentially what's saying, drafts are fine, meetings are fine, just don't make your decisions until you get to the IEP meeting. Now, the substantive issues. There's attorneys for, many attorneys use the term shoehorning, which is an inappropriate practice, and that's deciding on a program before you decide on the actual contents of the child's IEP. Before you decide on the goals, you make the program decision first. And the reason it's called shoehorning, when you think of a shoehorn, you kind of fit your foot into the shoe, and that's the idea behind deciding placement before you do programming. So in other words, we need to determine F.A.P.E before we get to placement. Another big substantive error is failing to address problem behavior or any of the other five. There's 5 special factors we have to address in the IEP, and it's very important that we look at all those. But probably the one that gets the most attention in the courts is when kids have problem behaviors that are not addressed in the IEP. I've read cases and hearings where school district IEP teams have not talked about behavior because the kid's primary disability wasn't emotional behavioral disorders. So they didn't discuss behavior. Well, if a child has problem behaviors, it doesn't matter what you call them, you have to address that need in the IEP. In fact, courts are not overly concerned about categories. They're concerned about needs, that we address all of a child's needs. So make certain that you address all those factors, especially behavior. And remember, in the Endrew case, that's one of the things the school district really fell down on, was behavior. Well, under that old de minimis standard, that may have been okay, but it's not okay anymore, I don't believe. So, failing to properly assess all of a student's needs, it's kind of related to what I just talked about. Remember to, in that present level statement, if you found there's an error, if you know there is a problem area with a child, you need to address it in the assessment. If it's in the assessment and it's not addressed in the rest of the IEP, fatal error. Now I'm a state review officer in South Carolina, and we're in what we call a two-tier state. If there's a hearing, it's done at the local level in the school district where they say, you know, parents want a hearing, call for a due process hearing. When I used to be a hearing officer, might get a call from a school district and say, we need a hearing officer, will you come and serve as a hearing officer? And there's like 10 hearing officers in South Carolina. But if say the parents lose at the hearing level in South Carolina, they then appeal to the state. Now in Indiana, they would go right to a court. But in South Carolina, they go to the state. Now I'm a state review officer, and what we do is in state reviews is we don't have the hearing over again. I just get the 1,500 pages of transcripts, read them all, look at the exhibits, and then look at the facts of the case, look at the law, and decide, did the hearing officer rule correctly? Well, I just had a case in which a hearing officer had ruled that a school district developed F.A.P.E, and the first things I did was look at the IEP, and the present levels were filled with descriptions about the child's behavioral needs. When I looked at the goals and the services, no behavior there at all. That's an illegal IEP. You have a need, you have to address it. So remember, when you properly assess all of a student's needs, and you make sure you assess them. Now, next, a substantive error, failing to write measurable annual goals. I talked about this case out of Ohio called the Escambia case, where a school district was 2 years of IEPs were declared invalid because the goals weren't measurable. The goals would be stuff like Johnny's reading will improve. You know, just very broad statements. And, you know, at one time before 1990, goals didn't have to be measurable. It wasn't until 1990 reauthorization of the idea that all of a sudden goals had to be measurable. But if you failed to write measurable goals like they did in the Ohio case, you quite likely, if you went to hearing or a court, that would be declared invalid. How do we write? Here's a couple interesting things. I already talked about this Carter v. Florence case. Unambitious goals. That's what killed Florence County 4. And here's what the judge said. The stated progress on Shannon's goals in reading and math skills for an entire school year ensured the IEP's inadequacy from its inception. Even if Shannon had met her goals, she would continue to fall further behind her peers. The goals were wholly inadequate. Florence County School District failed to provide Shannon with a F.A.P.E. What they did is, remember I said Shannon was in 9th grade, reading at a 4th grade level, and the goal said in 1 year's time, Shannon would progress on a standardized norm reference test to 4.3. And the judge said, 3/10 of a year's growth in 1 year's time for a child who's already way behind just is ridiculous. Because if she meets it, it's kind of like, so what? So you want to err on the side of ambition. Again, be reasonable, but err on the side of ambition. Overly general goals. This was out of Case, New Mexico. IEP goals were just very general, increasing reading ability. Students' annual goals and objectives in each IEP simply do not contain objective criteria which permit measurement of the student's progress. A goal of increasing reading comprehension skills or improving decoding skills is not a measurable goal, even if the present levels of performance were clearly stated, which they were not in this case. An open-ended statement that a student will improve does not meet the requirement of a measurable goal. So again, you want teachers to write, you want your IEPs to contain goals that are measurable, and you want them to contain really you want them to be really measurable. I have talked before, and I know this is the IEP Matt and Jolly and everybody have this in the Resource Center. Best way to write a measurable goal was developed by a guy named Robert Mager in 1953. And he said 4 things in a goal will make it measurable. Put your target behavior in. That's what you want to change from the need. That's from your assessment, your present level statement. Target behavior has to be visible, like to count, to read aloud, to write how many words. Can't be invisible, like to enjoy, to appreciate, because you can't measure that. So visible target behavior, stimulus, material, or condition, that's how you're going to measure change. Barbara Bateman talks about that. She calls it the given, that given something something, given a 3-minute story or story starter in 3 minutes to write, Stacy will write so many words. That stimulus material. Third, you need a criterion for acceptable performance, just how you're going to know the goal is achieved. Like if, the child will write, 103 words within 3 minutes or something like that. But it's got to be measurable, the criterion for acceptable performance. And then timeline. And you don't necessarily have to have that, Mager said, but if you have the timeline in the goal, that improves it. But the first 3 are really important in terms of writing measurable goals. Error number 10, substantive, failing to collect data to show progress. That's very important, especially given the new Endrew standard. We have to have data to show progress. If we can show student progress, every F.A.P.E case I've ever read that have been decided in favor of school districts have involved them having data that showed progress. If they can do that, again, you have almost an unassailable IEP, because that, remember, the substantive is the most important part of the IEP. So if you can show progress and it's real data, you probably have a legally correct IEP. Now, this is a case out of New York. It kind of gives us caution, the old teacher observation, measuring by teacher observation. That's not an okay thing, because in this case, an IEP was declared to be invalid, did not provide F.A.P.E, because the goals contained this ubiquitous measured by teacher observation, measured by teacher observation. But there was no objective measure in the IEP. And what the judge did in this case is, although subjective teacher observation provides valuable information, teacher observation is not an adequate method of monitoring student progress. Because without supporting data, teacher observation's opinion, which cannot be verified. Now think about the new Endrew standard. How likely is it that a court using this new standard would accept teacher observation? Not very likely, in my opinion. Another one, this is also from the New Mexico case. Remember, they had very vague goals. The students' annual goals and objectives in each IEP simply did not contain objective criteria that permitted measurement of the student's progress. Again, a goal of increasing reading comprehension skills does not make it. That is a very important thing that we remember about measurement. Error 11, failing to link the assessment, the goals, and progress monitoring and services. So in other words, the IEP really has to link all these elements. Barbara Bateman, in a book she did a number of years ago, excellent book, called Better IEPs, talks about the assessment as the baseline from where we begin. I think of it like a keystone. It's the thing upon which everything else is built upon. So if your assessment's bad, and courts have said this many times, if the assessment is incorrect, you don't address all the child's needs, then the rest of the IEP will probably be correct too. But also, if you have an IEP that has an assessment and says there's a need and you don't have goals or services to address that, that is also an error. In 1997, the U.S. Department of Education wrote a question and answer document, which you can go to the OSEP website and get all these documents they put out periodically as guidance to school districts in following the idea. One of the things they said is that if we don't connect the assessment to the rest of the IEP, we likely will have an illegal IEP. And they gave the example of reading. They said, so if you have a need in reading, you better have a service that addresses reading. You better have a goal that addresses reading. And to the extent that breaks down, it makes it more likely you'll have an IEP that doesn't confer FAPE. And that's what I wanted to say, is that the present levels of performance statement, that underlies everything in the IEP. If that's not correct, the rest of the IEP, and courts have said this, will probably not be correct either. But from that, if we say there's a need, we have to address it in the annual goals. We have to address it in the services. If it's an educational need, we need goals and services. Now, not all needs are going to need goals, but all needs are going to require services to address those needs. And, of course, we have to monitor progress. And the extent we're goofing up any of those areas, say we have a need and a reading need and no goal, or a reading need and no service to address that need, or we have a reading need and we don't monitor progress in reading. Anytime we see that X there, that means we may have an illegal IEP, or we may have an IEP that doesn't confer FAPE. This is the one. This is from that IDEA OSEP document I was talking about from the regulations. Question was asked, and anybody can have a question right to OSEP, and they likely will answer it and very likely will publish it if they think it's an important question. The question here was, what is the relationship between the present levels of performance and the rest of the IEP? And what they said is there should be a direct relationship between the present levels of performance and other components of the IEP. Thus, if a statement describes a problem with a child's reading level and points to a deficiency in reading skills, the problem should be addressed under both goals and specific special education and related services provided to the child. So in other words, we have to have that linkage from assessment to present levels, goals, services, and progress monitoring. Error number 12 is failing to provide a special education program that confers meaningful educational benefit. And that's really the meaningful, I should have put in quotes, because although the Supreme Court didn't say meaningful, they said clearly it's educational benefit. Progress that exceeds the so-called de minimis standard. And the 13th that I already talked about was the implementation. That's kind of the new line of cases we're getting on FAPE. That school districts are, if they fail to deliver the services listed in the student's IEP, that may be, if we consider, like the Ninth Circuit did, which I think we always want to err on the side of safety, if we consider the IEP to be a contract, as the Ninth Circuit said, that means we have to honor all the elements of that contract. We want to make good faith efforts. Remember, the IEP is not a guarantee of success, but we have to implement the IEP. If we can show progress and have an IEP that we have measurable annual goals, we actually measure them, we make changes if students need it, we collect data that show progress, we have virtually a legally unassailable IEP under the new standard and under any standard. So one of the things we want to do in implementation is use that IEP at a glance type thing to develop a mechanism to ensure that all staff are exercising their responsibilities under the IDEA, and ignorance is not an excuse. Or as Julie Weatherly has said, the IEP is not a list of suggestions. What we put in the IEP is to be implemented as written. Were there any other questions? We've gone through a lot of stuff today, but yes, ma'am. I always have, one answer I always have is, whatever your school district says, that's what you need to do. Whatever your school district's position is. But I would say in those cases, what does the school district say? But I would say he's 18 years old. That's his IEP now. It's not his parents. If he doesn't want the parents involved, they're not involved. We had a case in South Carolina where a child was 18, had moved to Columbia from Myrtle Beach. It was like 2 hours, 45 minutes. had an IEP meeting. His parents drove all the way from Myrtle Beach. He said, I don't want you here. And they were excused. And the director called Barbara Drayton, who's our attorney for the school district, and said, absolutely. If he's 18 years old and he says he doesn't want the parents there, they shouldn't be there. So thank you very much.